forgot, or when they didn't know, is that the property, when you have an armed robbery, the prosecution don't treat you as a role. And so the man, what is the young boy, 15 years old, you have the right to remain silent.
You do not have to sign anything. Of course, the better practice for the police is to get the person to sign something.
Read to me. Does that mean my case gets...
Remember that officers are human beings just like us. Remember that officers are human beings just like us, and how you respond to them will affect how they respond to you. So no matter how you're approached, you should always be respectful and kind. Address them by sir, officer. Oftentimes I try to promote them and say, Lieutenant, what's going on? So the first thing I would suggest is be respectful and kind to them. Second of all, the question really incorporates several issues. Number one, why have you been stopped by the officer? And I'll speak to that in a minute. And then it addresses the issue, what questions must I ask? And what about search issues? In response to the first issue, why have I been stopped? There are really two categories in which individuals may be stopped. Number one is what we call articulable suspicion. They have reason to believe, a reason that they can articulate to believe that maybe a crime has been committed and you may have information relevant to that. For that basis of stop, they can only do a limited questioning and a limited pat-down. I'll talk about that in a minute, as distinguished from a full-fledged search. If you're stopped because they have what they call probable cause, probable cause is more than articulable suspicion. It means that they have good reason to believe that a crime has been committed and that you have committed it. So for example, if there was a report of a robbery and they said the robber fled off in a green car and you're driving down the highway in a green car, that may be articulable suspicion. But if it's reported that it was a green car driven by an African-American male wearing a pink hat, and the officer observes you during that, then now he has what we call probable cause. When you're approached by the officer for what we call articulable suspicion, just want to talk to you. Anytime you're approached by an officer, the only questions you have to provide are your name and date of birth. Beyond that, you do not. I was talking to a member of the audience earlier this morning, and they were stopped by an officer for a traffic stop. The question presented was, do you know why I stopped you? You don't have to respond, officer, you must have stopped me because of that stop sign I ran.
Please don't.
Really, in that circumstance, all you have to do is provide your name and birthday. And again, I encourage people not to get into confrontation. I would say, officer, respectfully, all I want to provide is my name and birthday. If they're insistent upon that, do not engage in a confrontation, because then you can be charged with obstruction. Answer the question and let your attorneys deal with it later on. As to the issue of search, assuming that, as a general rule, you or your property cannot be searched without either a warrant or probable cause. That's a general rule, and there are about 1 million exceptions to that general rule. The big exception, the trump card to that general rule, is except if you consent. And so my advice is always respectfully say, officer, with all due respect or respectfully, you do not have my permission to search the car. Now, if they go ahead and search anyway, should you wrestle them down? Should you stop them? No. Step back, let them do the search, and let your attorney handle it later on.
That is excellent advice from our panelists. And on that note, of question that, and I'm sorry, my practice is being the attendant associates, and I practice a variety of practice areas, including criminal defense as well. And a lot of times people will say when they come in for a consultation, well, my rights weren't read to me. Does that mean my case gets thrown out? So, Shavita, if you could tell us what reading of rights we're talking about. I think most people know they're referred to as Miranda. What are Miranda rights, and what is the implication of an officer not reading your Miranda rights?
Again, the lawyer answer is it depends on the circumstances. Normally, if you are taken into custody, they have to read you your Miranda rights. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. If you cannot afford one will be appointed to you. There are some instances, however, that if they stop and talk with you, it's called the first level of an investigation. And so if you stand there and continue to talk, as a prosecutor, I'd love for you to do, then it doesn't matter, because at that point, they're just asking you a simple question, and if you volunteer the information, you're not in custody, so that Miranda does not kick into effect. And so whatever you say then will be used against you. However, anytime that you are taken into custody, or it is relayed to you that you are not free to go, even if they haven't put the handcuffs on you, that is a detention. And so at that point, before they can ask you questions, they do have to read you your Miranda rights, and you do have to consent. Or say, yes, I understand my rights, and yes, I want to talk to you.
And does that have to be in writing? Do you have to sign something before you make a statement?
You do not have to sign anything. Of course, the better practice for the police is to get the person to sign something, but it is not a requirement.
Does anyone else want to add something about Miranda rights?
Just to put the Miranda rights in context, in the background, the Miranda rights came as a result of a case, Miranda versus Arizona. And that was a young man who was arrested and charged with both rape and kidnapping. And after about 2 hours of questioning, he signed a written statement. And in that written statement said, in fact, he says, I know my rights and I'm giving this voluntarily. He was represented at that time by a public defender in that case, and he was convicted and served sentenced to 20 to 30 years. That case was ultimately appealed to the U.S. Supreme Court, and the Supreme Court said that for suspects who are in custody and are responding to questions, they must be informed of both their right to counsel and also their right to remain silent. And if they're not, the result is that their statements that they make cannot be used against them in a court of law. As a result of that hearing, there have been several rules which we now know as Miranda rights: the right to an attorney, the right to remain silent, the right to have an attorney present during questioning, the right, if you cannot afford an attorney, one will be appointed to you. Those came as a result of those cases. Now, two things I do need to point out. The Miranda warnings only apply in two circumstances. Number one, the individual must be in custody. So going back to that traffic stop situation, if the officer has merely stopped you and questioned you but has not placed you under arrest, it's not required to Mirandize you. The second requirement is it must be in response to questions by a law enforcement officer. So that if I'm arrested, I am in custody, and let's say I'm questioned with, let's say, my mother present, and I'm Mirandized, and then I say, well, I don't want to talk and I want my lawyer. Oftentimes what the police officer will do is just sit back and be quiet. But if my mother is present, she'll say, boy, you better tell the truth. Tell them what you did. Okay? Now, if I talk into that circumstances, remember, I am in custody, but it's not in response to a question by a law enforcement officer. And I see that a lot in juvenile cases. Or the person may be in custody, and the officer may say something like, well, you know, you can help yourself by talking, and then sit back.